The Supreme Court of Appeals has given independent media the green light to publish a leaked State Security Agency report that alleges that the United States of America was gathering information on the African National Congress. Now, independent media obtained this report in December of 2021, but the State Security Minister then had prevented them from releasing any information contained therein. Let's now welcome Heidi Swart, who is the Research and Journalism Coordinator for Intelwatch. Heidi, thank you so much for your time. Welcome. Look, in layman terms, what does this ruling specifically mean, not only for press freedom, but also for transparency as well as accountability in governance?
So this is a big win, I think, for civil society and for South Africa as a democracy as a whole. What the court has essentially said, in a nutshell, is that the state security forces cannot simply take a document, classify it, and then, based on that, prohibit the courts from looking at the documents to decide whether or not it can be released into the public domain. So what essentially happened first off was that the Gauteng Division High Court in Pretoria looked at the case and said, okay, no, you guys didn't do a PIA application for this. This is now independent media. You shouldn't have this report. So sorry, we are upholding an interdict that will prevent, and you can't write about this. So that's the decision in the end that the Supreme Court overturned, saying, no, they don't have to bring a prior application. It doesn't matter how they got hold of this document. The court can actually make a decision based on the content of the documents.
Very interesting indeed. Now, Heidi, in its arguments, of course, the State Security Agency had said that the security of the ANC officials would have been compromised if the report were to become public. But then, is this not a matter of public interest, as you've just alluded to?
Well, yes, quite. I mean, one of the reasons why the Supreme Court ruled against them was because the State Security Agency had argued, look, if this comes out, it's a threat to national security, but also, it's going to strain national and diplomatic relations. I think that was the other part of the motivation for it with the United States. So they had reasons to keep it, to want to keep it away from the public. They also told the Gauteng High Court initially that they considered this report to be top secret, when in fact it was only secret. So what top secret means is that there's a serious disruption of services, and there's also there can be a breakage of diplomatic ties, or perhaps even a declaration of war if a document gets out or gets leaked into the public. Secret basically means, look, things like diplomatic relations are going to get strained, and things are going to be disrupted, but there won't be grave consequences, as in the case of a top secret classification getting out. And so, in the end, this was in the public interest, not really so much necessarily for the content of the report, but for the fact that the agency was trying to keep secret something that didn't actually deserve classification.
Interesting indeed, because then you ask, who should then be the judge as to whether or not, state security or certain officials' security would be threatened. Now, Heidi, the minister Zizi they had argued for the report, saying that it will threaten national security, as you've just said. But is this not then akin to stifling media or press freedom in ensuring that we can actually do our jobs without fear or favor?
Yes, it is, absolutely. We still have in South Africa the Protection of Information Act of 1982, which is an apartheid relay. So, in essence, if the Gauteng High Court's decision had been upheld, it would have meant that any leaked document we wouldn't have been able to publish on. we would have to go through the PIA application, even if we have the document in our possession already. So a big issue with that is that it immediately gives the State Security Agency a chance to repeatedly deny the PIA application, right? Mm-hmm. But even a deeper issue is the fact that the State Security Agency has a tendency to say, no, sorry, we can't answer your questions. Sorry, and this is to the media. Sorry, we can't answer your questions because this is classified information and it's a threat to national security and our operations if we do actually comment. And in this case, that really wasn't the case, according to the Supreme Court, because much of the information was already in the public domains, and none of the ANC officials that were collaborating with United States intelligence officials were actually named in the report.
And with the latest developments, Heidi, I mean, when you talk about tendencies there, I mean, we've seen a precedent here where people are rushing to courts to interdict either their arrest or imminent arrest, as well as investigation. So let us shift our focus now to the new intelligence bill. We know that currently, as it stands, there has been a number of improvements, right, noted. But talk to us about some of the concerns with the bill in its current form.
So one of our biggest wins, I think, was the fact that the bill no longer allows for security vetting of non-profit organizations and churches in order to establish if they are a threat to national security. Mm-hmm. But what we have seen is that the Secret Services Account Act, which allows the State Security Agency currently to spend from a bottomless pit of money, really, in an unaccountable manner, that will be allowed to carry on. They've never really had an unqualified audit. And so it will continue to be the case where the Auditor General doesn't have access to their financial statements. Mm-hmm. And this comes back to the whole classification issue, which was an issue in this case, where they simply say, sorry, but we can't tell you what we spent our money on because it's classified information and it's going to threaten national security. Mm-hmm. So that's a major issue that's still there. Another issue that's also linked to the classification of documents and the agency's dirty laundry being aired out in the court is that our Inspector General of Intelligence still doesn't have the power when he or she does investigations into the State Security Agency to make legally binding recommendations. Mm-hmm. So if they investigate malfeasance and they find that there have been illegalities, all the IGI can do is to make recommendations to the Joint Standing Committee on Intelligence in Parliament, and traditionally that's where these recommendations have gone to die. And the State Security Agency fought to keep those recommendations off the books or sort of out of the courts because their argument was that they didn't want their secret operations being revealed in the courts because, once again, information should remain classified in the name of national security. So, yes, there's still huge issues with the bill. The bill's going to the National Council of Provinces. The bill doesn't really need their approval to be signed into law by the president, but we will make an effort to make additional submissions to see if we can't get some extra changes in there.
Thank you so much for that. We'll certainly be keeping a close watch on that. Heidi Swart from Intelwatch, thank you so much.